system. With regard to clause 3, NIPA has no objection to the provision of clause 3, as the word nomination and not election is more appropriate under the circumstances. In addition, NIPA has no objection to the provision of clause 3 intended to put a time frame within which a person is allowed to defect from one's political party and become an independent candidate. This time frame is 2 months before the date of nominations. NIPA's position is that this is important as it preserves order in political parties. This ensures that the position to contest as an independent MP is not from a point of principle and not expedience. With regard to clause 4, NIPA has no objection to the provision of clause 4A, intended to expand the category of persons captured under the provision to include mayor and council chairpersons not included in the current provision. NIPA also has no objection to the provision of clause 4B, as the words here and determine are more appropriate, and not merely the word here when it comes to court matters. It is the obligation of the courts to not only hear but also determine matters. With regard to clause 4C of clause 4, NIPA has no objection, as the proposal is meant to prevent the cancellation of nominations in circumstances where a candidate resigns or is disqualified by a court after the closing of nominations. The provision only provides for cancellation of nominations only in the event of death of a candidate. NIPA's position is that the current provision in the Constitution is susceptible to abuse and costly, as it requires reprint of ballot papers and preparations for fresh nominations when nominations are cancelled. With regard to clause 5, NIPA has no objection, as it relates to the holding of by-elections for independent members of parliament, independent mayors, councillors, council chairpersons and councillors. The justification here is that as independent members of parliament, independent mayors, council chairpersons and councillors do not belong to any political party, and hence not possible to fill a vacancy by way of a political party electing another person from the party to fill the vacancy. Then clause 6, NIPA agrees to the provision of clause 6, as it intends to take into account the proposed composition of the National Assembly, which shall include a mixed member proportional electoral system. Clause 7, there is no objection also there. This clause merely provides for the new proposed changes in terms of composition of the National Assembly. With regard to clause 8, NIPA has no objection also. This clause is proposed in recognition of the intended proportional representation electoral system. As regards clause 9, clause 9A, this clause is intended to amend the provision in the current Constitution that provides for disqualifying a candidate based on the decision of the Constitutional Court rather than being based on the provisions of the Constitution as determined by the Constitutional Court. So there is no objection there. Clause 9B of the bill, NIPA has no objection to the same. This clause intends to eliminate the need for holding by-elections whenever a vacancy arises in the National Assembly for a member of parliament, which has proved to be costly to the nation, and public outcry has generally been that by-elections are a huge burden to the nation's treasury. With regard to clause 9C again, NIPA agrees to the provision, as the clause merely intends to provide that a person elected as member of parliament by a political party following a vacancy shall serve for the unexpired term of parliament. In addition to that, with regard to clause 9C, where there is no objection, the clause provides that a person elected as member of parliament by a political party following a vacancy shall meet the requirements specified under Article 70 for eligibility to be elected as a member of parliament. There is no objection to that. The said clause also provides that a by-election shall not be held within the 180-day period preceding a general election, even if a vacancy arises. We don't object to that. The last of clause C is that the Electoral Commission shall by regulations set the date and time for submission of the name of the person elected by a political party following a vacancy, as well as guide on the time frame for the completion of the same. We don't object to that provision. With regard to clause 10, there is no objection. This clause, on the basis that it is the obligation of the courts to not only to hear but also determine matters. This is just one of the lacunas in our constitution, which is being put clearly here. Then clause 11, NIPA has no objection to clause 11 as it relates to the term of parliament, as the clause is changing the commencement of the term of parliament from the current provision which provides for commencement of the term when members of parliament are sworn into office. It's being changed to the first sitting of the National Assembly after a general election. We have no objection to that provision. NIPA is of a view that it is just proper that the term of parliament begins from the first sitting of parliament rather than from when the members of parliament are sworn into office. In addition to that, as regards clause 11, NIPA has no objection as it relates to extending the term of parliament for a period not exceeding 12 months when the republic is at war, as the situation may not favor the holding of elections in those circumstances. Furthermore, in relation to clause 11, NIPA does not object as it relates to the dissolution of parliament a day preceding the date of the general elections. This is what would make a complete term of 5 years. The current provision in the Zambian constitution providing for the dissolution of parliament 90 days before the next general elections does not give parliament a complete 5-year term as provided under the same constitution. Further, in clause 11, NIPA does not object as it relates to providing for parliament not sitting or conducting any business 90 days before the holding of the next general elections. NIPA is of a view that this is so in that the 90 days is meant to provide the space for members of parliament to campaign for the next general elections. Furthermore, as regards the same clause 11, relating to the president dissolving parliament in circumstances where the executive cannot effectively govern the republic due to the failure of the National Assembly to objectively and reasonably carry out its legislative function, NIPA does not object, and the view of NIPA is that this provision exists in the current constitution and is meant to ensure that parliament objectively and reasonably carries out its legislative function without disrupting the running of government. Further, the same clause 11, NIPA does not object as it relates to the president informing the public and referring the matter to the Constitutional Court concerning the dissolution of parliament in circumstances when the National Assembly is dissolved by the president due to the failure of the National Assembly to objectively and reasonably carry out its legislative function. Still, on clause 11, NIPA has no objection as it relates to the Constitutional Court hearing and determining within 7 days of receipt of the matter concerning the dissolution of parliament in circumstances where the National Assembly is dissolved by the president due to the failure of the National Assembly to objectively and reasonably carry out its legislative function. Furthermore, in relation to clause 11, NIPA does not object in terms of the clause providing for the Constitutional Court deciding and informing the President to dissolve the Parliament in circumstances where the President decides to dissolve the National Assembly due to the failure of the National Assembly to objectively and reasonably carry out its legislative function. NIPA is of a view that this is so in that the determination as to whether Parliament be dissolved for failure to objectively and reasonably carry out its legislative function shall be made by the Constitutional Court. NIPA also does not object.
Order witness, can you be a bit loud in your submission?
NIPA also does not object with regard to the said clause 11, providing for the President continuing to perform the executive functions until the President-elect assumes office in circumstances where the National Assembly is dissolved by the President due to the failure of the National Assembly to objectively and reasonably carry out its legislative function. NIPA also does not object to clause 11 in which as it provides for the holding of elections within 90 days of the dissolution of Parliament in circumstances where the National Assembly is dissolved by the President due to the failure of the National Assembly to objectively and reasonably carry out its legislative function. Furthermore, as regards clause 11, there is no objection, NIPA has no objection as it relates to the President recalling the National Assembly that was dissolved before a general election or a National Assembly that was suspended in circumstances of war, state of emergency, or threatened state of public emergency. NIPA is of a view that this is so in that in the stated circumstances, certain government decisions may need the approval of the National Assembly. Hence, they need to recall the National Assembly that was dissolved or suspended. Finally, as regards clause 11, NIPA has no objection in terms of the clause providing for the President proroguing Parliament in consultation with the Speaker. NIPA is of a view that this is so in that there are circumstances when it is necessary to prorogue Parliament, such as the threatened public health situation. Clause 12, there is no objection from NIPA. This is justified, the clause, as it is the obligation of the courts to not only hear but also determine matters. Clause 13, NIPA does not object to clause 13, which provides that the office of minister shall become vacant 90 days before a general election. NIPA is of a view that this provision is justified in that it is in line with the current constitution, which provides for the 90 days before general elections as the campaign period. This will ensure that ministers will not be in office and thereby use public resources to their advantage during the campaign period. Clause 14, NIPA has no objection as it provides clause 14A of the bill that provides that the office of provincial minister shall become vacant 90 days before a general election. Again, NIPA's position is that this provision is justified in that it is in line with the current constitution, which provides for the 90 days before general elections as the campaign period. This will ensure that provincial ministers will not be in office and thereby use public resources to their advantage during the campaign period. NIPA also has no objection as regards to clause 14B that provides for renumbering of clauses 3 of Article 117 as clause 4. With regard to clause 15, NIPA does not object to that clause again that provides for the insertion of the word electoral immediately before the word boundaries. This provision is justified as it clarifies that the boundaries are simply for electoral purposes. With regard to clause 16, NIPA does not object to the same. The provision provides for the deletion of the figure 47, that is Article 47.3, and the substitution thereof of the figure 47.4. NIPA also has no objection to clause 16B relating to the inclusion of a member of parliament into the council. This provision is justified as it intends to include members of parliament into the council, which is not the case under the current constitution. NIPA also has no objection to clause 16B relating to the renumbering of paragraphs B and C as paragraph C and D respectively. NIPA has no objection to clause 16C, providing that the term of a council shall be 5 years commencing from the day of the first sitting of a council after a general election and ending on the day parliament is dissolved. This is just proper. It is NIPA's view that it is just proper that the term of a council should begin from the first sitting of the council rather than from when the councillors are sworn into office. NIPA has no objection to clause 16D, providing that a council shall not sit or conduct any business 90 days before the holding of the next general election. This provision is justified in that the 90 days is meant to provide space for mayors, council chairpersons and councillors to campaign for the next general elections, as it is the case with members of parliament. Then clause 17, NIPA has no objection to it as it provides for the eligibility for election of mayor and council chairperson. This is because the current constitution does not provide for the eligibility for mayor and council chairperson. In addition, the proposed eligibility criteria is the same as applies to members of parliament. So NIPA does not object to that. Then still in clause 7, NIPA does not object in terms of where it provides for the election of a mayor or council chairperson directly in accordance with Article 47(4) of the current constitution, which provides for the election to be conducted during elections for councillors as prescribed. Also, NIPA does not object to clause 17 where it provides for the election of a deputy mayor and deputy council chairperson by councillors from amongst themselves. NIPA's view is that this is what is provided in the current constitution and it does not raise any contention. Clause 18, NIPA has no objection to clause 18 that provides for filling of a vacancy in the office of mayor, council chairperson or councillor by a political party that sponsored the mayor, council chairperson or councillor. NIPA's view is that this clause is intended to eliminate the need for holding of by-elections whenever a vacancy arises in the office of mayor, council chairperson or councillor. This has proved to be costly to the nation, and public outcry has generally been that by-elections are a huge drain on the country's treasury. Still on clause 18, NIPA does not object as far as the clause provides that a person elected as mayor, council chairperson or councillor by a political party following a vacancy shall serve for the unexpired term of a council. Furthermore, as regards clause 18, NIPA does not object as far as it provides that a person elected as councillor by a political party following a vacancy shall meet the requirements specified for eligibility to be elected as councillor under Article 153(4) of the current constitution. NIPA does not also object to clause 18 insofar as it provides that a person elected as mayor or council chairperson by a political party following a vacancy shall meet the requirements specified for eligibility to be elected as mayor or council chairperson under Article 154(2). NIPA also does not object to clause 18 as far as it provides that an election shall not be held within the 180-day period preceding a general election, even if a vacancy arises in the office of mayor, council chairperson or councillor. This is the proposed position in relation to members of parliament. NIPA also has no objection to clause 18 as it provides Article 18 where it provides that the Electoral Commission shall by regulations set the date and time for submission of the name of the person elected by a political party following a vacancy in the office of mayor, council chairperson or councillor. Finally, with regards to clause 18, NIPA has no objection also as far as where it provides that the Electoral Commission shall by regulations guide on the time frame for the completion of the process relating to the setting of the date and time for submission of the name of the person elected by a political party following a vacancy in the office of mayor, council chairperson, or councillor. In relation to clause 19, NIPA has no objection to clause 19, providing for the insertion of the words "and determined" immediately after the word "head." This is showing that it is the obligation of the court not only to hear but also determine matters. In clause 20, NIPA does not object to the clause where it provides for the deletion of the word 10 and the substitution thereof of the word 5 immediately before the word years. This provision is meant to reduce the qualification for appointment as secretary to the cabinet in terms of experience from 10 years experience as permanent secretary or equivalent rank to 5 years experience as permanent secretary or equivalent rank. NIPA is of a view that the requirement for 10 years experience as permanent secretary reduces the availability of persons qualified to be appointed as secretary to the cabinet. With regard to clause 21, NIPA does not object. The clause provides for the deletion of paragraph B of Article 178(1) of the current Constitution and renumbering of paragraph C and D as paragraph B and C respectively. This provision is, NIPA is of a view that this provision is justified as the Office of Attorney General is not a political office and therefore should not cease automatically upon a new president assuming office. NIPA has no, with regard to clause 22, NIPA has no objection to clause 22, providing for the deletion of paragraph B of Article 179(4) of the current Constitution and renumbering of paragraphs C and D as paragraphs B and C respectively. NIPA again is of the view that this provision is justified as the Office of Solicitor General, just like that of Attorney General, is not a political office and therefore should not cease automatically upon a new president assuming office. As regard the last clause, which is clause 23, NIPA has no objection to clause 23, providing for the definitions as provided. These are the submissions, Chair, by NIPA. Thank you.
Thank you, witness. Honorable members, that's the submission from National Institute of Public Administration, School of Law. We may begin to interact with them. Honorable Banda, then Honorable Kambita. In that order.
Thank you, Chair, and thanks so much, witness, for your submission. It seems you have got no objection to all the clauses in this bill. Now, there are some concerns from the public out there who are saying this bill is illegal. In your view, where do you think it has lost its understanding? I thank you. I submit.
Just for guidance, Honorable Member, we may not discuss the speculation in the public, but the bill is rightfully before Parliament. Nonetheless, Honorable Kambita.
Thank you very much, Chairperson. National Institute of Public Administration, I refer you to your submission on clause 16, which speaks to the term of office. Is it clause 16 which speaks to the term of office for National Assembly or members of Parliament? Kindly help me, honorable members. 16? Yes, on page 8. So, my question, in asking my question, I want to refer you to also the act itself, I mean the bill. And the provision in the bill I think we start with 11, which speaks to the term of Parliament, and term of office of a member of Parliament shall be 5 years, commencing from the date of the first sitting of Parliament after a general election. I would like you to take note of the phrase first sitting of Parliament. Traditionally, the first sitting of Parliament happens, I think, approximately a month and a few days from the date of election, effectively reducing the period by a month or so from the 5 years. So I'd like you to reconcile the consistency of the phrase shall be 5 years, and this is the constitution we are dealing with, which also, if you read Article 1 of the Constitution, emphasizes its supremacy to the fact that there shouldn't be ambiguity or inconsistency within the Constitution itself. So I'd like you to suggest how we can probably put the right wording to ensure that we maintain the 5 years. Not only that, traditionally as well, not only do we start counting from the date when members are elected, but in the Constitution we want it to be written that from the date the Member of Parliament is sworn in. If we start from the date when the Member of Parliament is sworn in, then effectively will be inconsistent with the 5 years term. The same applies to the local government elected officials. So how do you suggest that we should cure this? I've seen even the previous Constitution 2016, Amendment Act number 2 of 2016, the wording is similar like that, and there is that inconsistency between the 5 years and the date of the first sitting. First sitting effectively knocks off from the 5 years. So how do you suggest that we should be consistent with the 5-year term? I submit.
Honorable Kandafula.
Thank you, Chair. I think it's sort of like, I think I can also as well say like wedding on clause 18. When you talked of a political party to fill in the vacancies in case of any eventuality. Now when you talk of voting, I don't know if we can call it an election, but otherwise from what you have tabulated, can't we probably maybe remove a person who is elected by a political party to a person who has been appointed? Because when it comes to election, I think it should be very broad, where even those other opposing people can at times change, because even within the same party, there are factions. I submit.
Witness, you can respond to the 3 questions from the honorable members.
Okay. Thank you very much, Chair. I think my colleague will start first.
Just guidance from the chairperson. There was a question that was based on the public. Is it still? Yes. Can we still respond to it?
No.
Yes.
No, you can respond to the 2 from Honorable Kambita and Honorable Kandafula.
Okay, so maybe let me start with from Honorable. Yeah, I think it is based on the election of a member of Parliament by a political by a political party. I mean, to avoid, that is actually to avoid by-elections, isn't it? Okay. So so where the Honorable has a problem with the word elect instead of appoint, because what is provided for in the bill is political parties shall elect. So that is actually what, for me, I think that is more appropriate than appoint. Because if I look at that particular provision, I'm of a view that there will be an enabling probably act or statutory instrument or regulation to provide how such an election shall be carried out. Because in whichever way we look at it, expenses relating to the filling of a vacancy, relating to which occurs after maybe death and so on, the expenses will always be there, because that's what democracy is all about. But I want to believe there will be, it is my view that there will be probably an SI or regulations that will provide how this will actually be done within the structures of a party. I can give an example. I think political parties, they usually know how they do it during nominations. I'm just giving an example. Because really, if we just leave it to political party shall appoint, how? Whichever way we look at it, I feel that the Electoral Commission will still be involved in the election of a member of parliament by a political party within the structures of a political party. That in itself will reduce the expenses that relate to the filling of a vacancy, because currently, of course, we know the expenses that relate to by-elections. I have actually, my view is that there will be regulations that will provide it, that will guide on how parties will be able to fill such a vacancy. Because if you say appoint, maybe what if I mean, these structures within political parties differ. You find sometimes, what if the appointment is just by the top, where maybe only 4 people sit and actually propose a name? So there should be some resemblance of democracy that takes place within the structures of the party. I think that really will be actually probably be guided by a prescribed by regulations also. So that is actually my opinion on the same.
I also wanted to add to say appointed. I wanted to add, Chair, that appointment sounds undemocratic, like my colleague has said, because we know that political parties, when they select their candidate for adoption, when they are adopted for elections, there is a process that is followed. So we believe that in that same vein, even if there is no law, and we don't have a law on political parties, structure, governance and everything, so even if there is no law in place to that effect, but the same processes which are democratic should be used than appointing someone, because this will be a situation where someone doesn't even know the constituents, and because he's a nephew or a son to someone, then they say, no, the people of so and so, this is your MP, and there are no elections. The moment you're appointed, you are the MP. So in the constitution, if we say election, it would be easy even to challenge if the process was not democratic than appointment. Appointment sounds more, it's not democratic. Thank you.
The one for Honorable Kambita. Honorable Kambita.
I think what I meant to refer to is clause 11 and clause 16. Clause 11 and clause 16.
On the same question, I understood the question.
You understood the question,
yes,
right?
So the question relates to the fact that we have elections in August, and then Parliament only, the first sitting comes in September. But by then, so the question is, how does it clock 1 year? Because it means that the MP must have been MP from September of the election year until September the other year after elections. Maybe the one way to circumvent it is maybe to say now Parliament cannot exist after general elections. To say the MP should continue into office until the first sitting of the of Parliament after the general election.
Can I add maybe something?
Can help your
Yeah.
director. Yeah.
I think, Honorable Kambit, actually your question, actually, it is quite very difficult to address on the basis that we have a fixed date when elections are held, actually August. And this is actually the problem also regarding the current constitution. If you look at the term, it is not 5 years. And actually this particular bill tries to resolve the problem by actually providing that Parliament shall be dissolved a day before, MPs will remain actually a day before the general election, isn't it? Yes, so it's actually what this current bill is trying to resolve is actually the question that you have asked. But it may not be resolved fully. Yeah, it's because we have a fixed date when elections are held.
Question, Honorable Kambita. You can switch off your mic.
Would it be your considered view then, because I think what is bringing the problem in this particular article or in these separate articles is tying in one sentence the sitting of Parliament and the term. Why don't we separate the two, the term and the sitting, the office of the member of Parliament? Why don't we tie it to the election, from the time the member of Parliament is elected to the time another one is elected? Because that resolves the 5-year problem, without which we will still have a gap, either at the end or at the beginning. I submit. What do you think?
Honorable Mngantu. It's the same question?
No, it's a new question.
Okay.
Clause 3. Clause 3 on page 3. You have said the last. Yes. Your last paragraph. In addition, NIPA has no objection to the provision of clause 3 intended to put a time frame within which a person is allowed to defect from one political party and become an independent candidate. This time frame is 2 months before the date of nomination. Now my point of clarification, this date of nomination is determined by the Electoral Commission of Zambia and is not fixed. What if the Electoral Commission of Zambia, since the wording of this clause says 2 months before, what if the Electoral Commission of Zambia sets the nomination date 30 or 54 days before the general election? What happens to the independent candidate that would want to contest on a political party? And why put the restriction? I submit.
Yeah, you can, because the one from Honorable Kambita was just a comment. So, Honorable Anakoka.
Thank you, Chair. The proposed amendments to Article 52, which I think in your presentation is, you are identifying it as under Clause 4. In relation to what happens, one, if a candidate withdraws. Currently, in the Constitution, the elections are automatically cancelled. But now, Bill 7 is proposing that this election should go ahead. Have you applied your thoughts to a situation where a candidate withdraws too close to the holding of elections, such that even if they withdraw, it's not practical for ECZ to remove their name and face from the ballot paper? So the person has withdrawn, but the election will be held with their face and details on the ballot. If you have applied your thoughts to that, how is it a desirable situation? If not, any ideas of how that can be resolved? The second one is, in the case of death, where we are saying the elections should be cancelled, we maintain the status quo, and it must be held within 30 days after calling of fresh nominations. The proposed amendment does not address the question of how soon should this election be called. It just says 30 days after you call for elections, but it's open as to, after cancelling elections, do you call these elections within 30 days also, within 90 days? And a sub-question to that one is, if a period is to be included, a time limit, should it be the same for presidential elections as for parliamentary elections, given that the preparations for the two are quite different? Thank you, Chair.
The elector can respond to 3 questions, 1 from Honorable Mngandu, 2 from Honorable Anakoka.
The question to do with, thank you very much, Chair. The question to do with the independent candidates. Our understanding of the provision is that, unless I'm guided, is that it relates to a candidate who belongs to a political party and now defects to become an independent. I heard the question was like put the other way around. Maybe I seek clarity on the same.
It's not that I'd put it the other way around. What I was trying to clarify is the 2 months resignation requirement. We have a date before the date of nominations, and this date of nomination is not prescribed. It's determined by the Electoral Commission of Zambia. What if we put it this way, where the requirement is 2 months before the date of nominations? Then the Electoral Commission of Zambia puts the date of nomination 1 month, 28 days. Don't you think it will defranchise those that would want, who have been left on a political party and would want to contest as independents? How fair do you think this 2 months requirement to an unknown date is? I submit.
Okay, I think the question is valid. I've actually, we have taken note of I think the concerns raised by the Honorable is that at least the date of election is fixed, so the 2 months can easily be determined. But the nomination is actually set by the Electoral Commission of Zambia. So meaning anyone who is probably not adopted by the political party may be at the mercy of the Electoral Commission of Zambia, depending on the date that is actually picked for nominations, isn't it? Yeah, it's valid. We'll take that one into account. Probably we may not provide the response right away.
Can respond the other 2 from Honorable Anakoka.
Yeah, the Honorable has raised something that I never thought of, really, concerning the withdrawal, resignation of a candidate before the holding of elections, isn't it? Yeah, I think if I understood the questions, that what if the resignation is just a few days, and you gave an example of 2 days before the elections, meaning the Electoral Commission of Zambia may not have ample time to remove the candidate that has resigned from the ballot, isn't it? Director.
It was just going through my mind. Somewhere I read about the Americans, where they have when such a situation arises. I remember when there were those elections, Kamala Harris, and there's an analysis that I read where they were saying when things have reached this stage, they can't remove the name from the ballot, but it's like they have a provision which provides, now that is the alternative that I can't recall properly, to say that person, even if the person wins, people vote for the person, but they will not be the winner. They have a diversion somehow, but I can't recall that diversion. I remember it intrigued my mind to say, okay, yeah, in that regard. But like my colleague has said, maybe that is something we can bring back again in shortest possible time.
Because what I see here is what the current constitution is trying to address. It's actually the chaos that can be created by perpetual resignation. And of course, we may see situations as this constitution is addressing lacunas in this current constitution. It's definitely to not really be 100% perfect. And this is why you find that actually certain provisions in this constitution shall be actually defects that may arise can only be cured by regulations of statutory instruments. But we are looking at really what is being cured. As much as there is actually what actually the Honorable has raised is actually one of the issues that really we need to direct our minds to. But what are we addressing? We are addressing a very, very serious problem which actually can create chaos in the country. Especially Article 52 in the current constitution is a very serious matter that requires the attention of this House of Parliament.
Just to echo to say that a constitution it can never be perfect in one instance. That's why constitutional amendments, it's an ongoing process. We cannot put everything together, and even if we put everything together now, those still have to be unbundled with time, because changes will still arise. And it follows therefore that we address the issues that are so more like prominent at each and every time that comes. Thank you.
Honourable members, do we still have questions? I think their submission was clear. Thank you so much, our witness. We lift your immunity. If you have any issues, you can submit through our clerks. Thank you.
Well, there you have it. The National Institute of Public Administration School of Law has made a submission before the Parliamentary Select Committee appointed to scrutinize the consortium of Zambia Amendment Bill, National Assembly Bill number 7 of 2025. And still to make a submission before the committee is the Common Grounds Network. Keep watching Parliament Television.
Watch the Parliamentary Select Committee that is scrutinizing the Constitution of Zambia Amendment Bill number 7 of 2025, live on Parliament Television and radio on Saturday 6th and 7th December 2025. Stay informed and engaged with the legislative process on Parliament Radio, DSTV Channel 272, GoTV Channel 28, Topstar Channel 5, National Assembly of Zambia Facebook and YouTube pages. Parliament Radio, Parliament TV, bringing Parliament closer to you.
Sometimes it's hard to fight. Some days I'm not alright.